All right, welcome everybody who's online, joining us online and in person. Thanks for coming. Just want to welcome you to the UIC Institute for the Humanities. This is the first event of the year organized by the Race and U.S. Empire Working Group. I want to thank our co-sponsors who helped make this possible: the Departments of Sociology, Criminology, Law and Justice, Global Asian Studies, as well as the Arab American Cultural Center. And special thanks to Katie Corboy for taking such great care of logistics. So we want to welcome a friend and colleague, Professor Lisa Hajjar, who's an internationally acclaimed scholar of law and society, human rights, military rule, and the war on terror. She's professor and chair of the Department of Sociology at UC Santa Barbara, and has previously taught at Swarthmore, Morehouse, and the American University of Beirut. Professor Hajjar is the author of 5 books, including her brilliant first book, Courting Conflict, on the Israeli military court system in the occupied West Bank and the Gaza Strip, Torture, A Sociology of Violence and Human Rights, and her latest book, The War in Court, Inside the Long Fight Against Torture, which was just released by the University of California Press. This is the book she'll be discussing tonight. It focuses on legal battles over the use of torture against people detained by the US military in Guantanamo Bay. Let's see, enable that. Lisa traveled to Guantanamo at least 14 times, 14 more? 14 times to conduct this research and to cover the military commissions there. The last time that Professor Hajjar was at UIC, it was part of the Geographies of Justice seminar series organized by the Social Justice Initiative, where she engaged in an unforgettable and highly clarifying and productive exchange with Charlene Carruthers of BYP 100 about retributive and restorative justice. Basically, should we lock up the torturers, the war criminals, and murderous cops, or should we abolish all prisons? So I expect that tonight's discussion will be equally electric. Lisa is going to speak first, and then we'll hear remarks from 3 panelists. Rona Kapadia, who's Associate Professor of Gender and Women's Studies at UIC and the author of Insurgent Aesthetics, Security and the Queer Life of the Forever Wars. Naomi Paik, Associate Professor of Global Asian Studies and Criminology, Law and Justice, and the author of Bans, Walls, Raids, and Sanctuary, as well as Rightlessness, Testimony, and Redress in US Prison Camps since World War II. And Professor Atif Saeed, who's the Assistant Professor of Sociology and the author of Revolution Squared, Tahrir, Political Possibilities and Counter-Revolution in Egypt, which is forthcoming from Duke University Press. After that, their comments, will have plenty of time for questions from the audience, both virtually and in person. So thanks again for being here, and welcome, Lisa.
Thank you all. Hi. I want to thank the people who brought me, Nadine Naber and Andy Clarno, and the 3 interlocutors today, Naomi Pike, Ronak, you're in there somewhere, and Atif Saeed. So the book, as Andy had very kindly introduced it, it's called The War in Court, Inside the Long Fight Against Torture. And I just want to talk very briefly about sort of what it spans. It really spans the 20 years. I mean, it starts with the beginning of the war on terror, and I finished, doing the final page proofs in the summer of the spring of 2022. So it's really a 20-year history. And the way I would describe it is that it's the anti-torture history of the war on terror. So Guantanamo constitutes a big part of that, because that became the main sort of the main locus of interrogation, detention, and then eventually attempts to prosecute people. But for those of you who are interested, I also look at all the fights that went on in terms of the battles that various lawyers waged in order to address and redress torture, in the Supreme Court, in federal courts, and also efforts to bring American torturers to justice, which unfortunately never succeeded. But I am going to concentrate my comments on Guantanamo specifically. And so I would just say that, one of the things like why I, was sort of ready to write this book. I was made to write this book because I'd been like, as joking with other torture people, that we were doing torture before it was cool. I was like doing torture in the 90s because my first book was on the Israeli military court system in the West Bank and Gaza. And what I really learned through that process of doing it was how significant torture was to Israeli strategies of control, but also that when a government sort of legalizes torture, as Israel had done, the only way to really fight it is, lawyers fighting it on the legal terrain. And that was so once the war on terror started, it was very easy for me to see early on that this was going to be a very similar kind of a phenomenon. And so now I'm going to just like hone in on Guantanamo. So the reason that Guantanamo was selected for the purpose that it served in the war on terror, just to, and it was originally and somewhat erroneously perceived, and I mean, understandably perceived as a legal black hole. Because, everything about Guantanamo, once the prisoners started being airlifted in on January 11th, 2002, everything about what was happening to them, who they were, et cetera, was a secret initially. So, but I want to just, put this into context. Like, why was the war on terror fought in the way in which it was? And why was torture such a central part of it? And it, one has to really appreciate going back to the beginning, the very important and nefarious role that then Vice President Dick Cheney played, and a small group of radical right-wing lawyers around him who seized upon the opportunity of the 9/11 terrorist attacks and the launching of a war on terror to pursue a kind of right-wing goal long held by Cheney, which was to expand presidential power under this idea of the unitary executive thesis. And so Cheney and these lawyers who put a legal varnish on this, they devised what they called the new paradigm. And the new paradigm had really two main components. One was to unfetter the power of the president, to enable the president, his actions not to be bound by laws, not to be subject to, oversight by Congress, or, to be subject to any judicial intervention. But the other aspect of the new paradigm was to, liberate American warfighting, particularly the treatment of captured, suspected enemies, from the laws of war. And so those were Cheney had convinced himself on the basis of absolutely nothing that the only way to get information from these shadowy enemies, whom at the beginning of the war on terror, they didn't even know who it was that they wanted, or who they were looking for. But they, the people convinced themselves that the only way to get information would be to use coercion and violence. And to use coercion and violence had to be kept secret. And so Guantanamo was selected, basically because these radical right-wing lawyers misunderstood American law and imagined that Guantanamo was beyond the reach of courts. And so it was this idea of Guantanamo being beyond the reach of courts, and the fact that the administration, the president, proclaimed upon himself the right to whomever he determined to be an unlawful enemy combatant could be held incommunicado indefinitely, and et cetera. And so that's why Guantanamo was selected. And its original purpose was to be an interrogation laboratory. So the war on terror really begins as a war for information, because the United States literally didn't know who they were fighting. And so the assumption, hubristic and ridiculous, but nevertheless, the executive power, was this idea that whomever they scooped up in Afghanistan was, or from elsewhere, was a terrorist. And if you were a terrorist, because the president had said, if you're in our custody, you are a terrorist, then you must have information. And so it was this kind of, these steps of irrational logic that lead to the idea that Guantanamo would just be a place where people would be interrogated in order to produce so-called actionable intelligence. But, because the United States fancies itself a nation of laws, unlike, a government, governments that engage in torture without bothering to justify it, the, lawyers, the government lawyers, particularly those in the Office of Legal Counsel, had to put kind of a legal varnish on what they were doing. In other words, the kinds of interrogation tactics that that the CIA wanted to use, that they wanted to use. And so what happened was that these lawyers, alongside the fact that people are being held incommunicado, in secret, but also that these government lawyers basically reinterpreted federal and international laws in order to say, for example, torture is bad, but these particular tactics don't rise to the level of torture as we interpret the law, and therefore it's not illegal and you can therefore use it. So it was like the legalization of torture. So just the beginning of the end of that, and this is where I think that lawyers played a very important role, was the first lawyers who really took on the Bush administration, and they did so very, very early. It was the late Michael Ratner, who was the executive director of the Center for Constitutional Rights, and a couple of death penalty lawyers, Joe Margulis and Clive Stafford Smith, joined him. And in February 2002, like just 6 months after 9/11, they'd learned the identities of a couple of Guantanamo detainees who happened to be citizens of allied Western countries. And they filed the first court case in federal court, Rasul v. Bush. And it was a challenge to the president's authority to secretly detain people. Well, let me just say that, the US courts were not prepared for any of this. And so the lower courts ultimately, they lost that case. But what happened in June of 2004 was the Supreme Court actually found in their favor. So several years after people had arrived at Guantanamo, the Supreme Court ruled in June 2004 that people detained at Guantanamo do have habeas corpus rights. In other words, they do have the right to challenge their detention, because the lawyers were saying, like, there's these guys here, they were just swept up, they're innocent, they are not enemies. And so that particular victory, one of the very few victories in the war in court, recognizing that detainees had habeas corpus. It was what was interesting, and this becomes a large part of my book, was what had immediately preceded that Supreme Court decision were two events in the spring of 2004. The Abu Ghraib photos were made public on April 28, 2004. Suddenly, all the government's lies were revealed as such, that, the government had been saying, we treat everybody in our custody humanely, we don't torture. And then you get these horrific photos of prisoners being tortured in a prison in occupied Iraq. And that scandal put so much pressure on the administration that and Congress starts finally asking some questions, that in late May and June, the government started releasing some legal memos and policy documents, thinking, okay, the questions are too great. They want to know what we're doing to prisoners. Okay, so here's some legal memos and Pentagon documents. But the contents of those documents were so shocking. It was like, in fact, there was a torture policy. It was authorized from the top, and it had been varnished with legal opinions. And so those two events prior to the Rasul decision got lawyers around the country of all different stripes and varieties angry. And so when the Supreme Court said that detainees have the right to be represented, hundreds of lawyers, corporate lawyers, human rights lawyers, family practice lawyers, whatever, volunteered to represent Guantanamo detainees. And so that was the birth of the Gitmo Bar. Another group of lawyers sort of where the idea that President Bush, along with saying that he could hold detainees incommunicado as long as he wanted, in 2001, he'd also established a military commission system. In other words, a system to try those individuals that the government would want to prosecute in a special tribunal run by the Pentagon called military commissions. And so when they started lining up the first those people who were at Guantanamo that the government thought they could prosecute, Osama bin Laden's driver, Salim Hamdan, some kangaroo skinner who joined the Taliban, an Australian kangaroo skinner who joined the Taliban, whatever. So the military lawyers were assigned to defend them. And the government's presumption, you know, again, like the government made so many hilariously stupid presumptions that proved fatally wrong for them. But what the government's presumption was that soldiers will just aye their orders. They will, you know, the order was, we want to prosecute these guys. You plead them guilty. We're going to get some guilty verdicts. We're going to ship, you know, we're going to prove to all of our critics that the system is working fine. And lo and behold, these military lawyers, we're talking just about a handful at the beginning, you know, basically they said that they're lawyers first, and they're not going to, like, you know, if they're representing people, they're not going to just obey orders about how these people should be and they're soldiers. You know, they said that this is not the purpose of the U.S. military. The U.S. military's purpose is to, you know, defend the Constitution. And so, you know, one of the cases that that also made it eventually to the Supreme Court challenged the constitutionality of the military commissions because they violated the Uniform Code of Military Justice. And that case was called Hamdan v. Rumsfeld. But the significance of that case, which was determined in June of 2006, when again, the Bush administration lost, and the most significant element of that case was that the Supreme Court, I mean, not a little testy Scalia, but, you know, 5 or 6 of the justices versus the right wingers at the time were still a minority, you know, basically said the Geneva Conventions actually apply to the treatment of detainees. And so that decision, as I write in the book, that was like, that killed the torture program, although it was deprived of a proper burial for a couple of more years. But it was that decision that forced the government to close the CIA black sites, because the CIA had been running its own torture program, rendition, and et cetera, in different countries around the world. So the 14 people who were detained in CIA black sites whom the government felt they could bring cases against. It was like Khalid Sheikh Mohammed, who was the alleged mastermind of 9/11, a few other people suspected of playing roles in 9/11, a guy suspected of being the mastermind of the bombing of the USS Cole off the coast of Yemen, 3 Indonesians who were deemed responsible for the bombing in Bali, and a few others were brought to Guantanamo and kept secret. So most of the detainees were held under military detention, were in military custody. And these guys, technically, the 14 that came in September of 2006, were also technically in military custody. But the most fascinating thing was that because they'd been tortured by the CIA for years, and the CIA owns all of the information about itself, their memories were deemed classified. So they were literally kept in a special facility. They could not talk to anybody. And the facility was, you know, although it wasn't acknowledged, but the CIA was still running them. And so that, you know, in the last year of President Bush's presidency, Bush, you know, and the Bush administration thought, we're going to put the 5 guys, Khalid Sheikh Mohammed and 4 others whom we can build a case against for the 9/11 attacks. We're going to put them on trial in the military commissions. You know, they were arraigned in June of 2008, you know, and the plan was to have them convicted and prosecuted and executed before Bush was out of office by the end of 2008. Well, that didn't happen, because in fact what happened was that, you know, the 5 guys, when they were in court in December of 2008, they basically said they would be willing to plead guilty on the sole condition that they be permitted to go directly to execution. But the law that was created to regulate the military commission hadn't conceived of that scenario. So anyway, Bush is out of office. Obama comes into office. Obama cancels the torture program, promises to close Guantanamo, promises to, you know, I mean, he suspended the military commissions. But what about the 9/11 case? I mean, that became the most significant case, as far as it was like, that was going to be the case that the US government, regardless of administration, was going to hang their hat on justifying Guantanamo and the military commissions, was that they were going to prosecute the people who had killed 2,976 people. So Barack Obama Originally, the plan was to prosecute these guys in New York. Then Fox News was mean to Obama, and Obama got sad, and so he canceled that plan. And then they rearranged them in the military commissions. And that case, which was, they were rearranged in 2012. The case is referred to in its shorthand by Khalid Sheikh Mohammed's initials, KSM2. And that case was in pretrial hearings from 2012 until March of 2022, when finally the government threw up its hands and said, let's just plea bargain, let's just get a plea bargain agreement out of this. And there's many, I'm happy to talk about how that, came about and what the implications were, but just the punchline, this is where I will sort of end it. I'm happy to talk about any of these things during question and answers, was that you just cannot have anything that even approximates justice. I mean, you can't even fool the most gullible people that a case or a legal process is fair when the people on trial were tortured. The government treats their torture as a secret, deprives the lawyers who are representing them from accessing information, menaces the defense lawyers, constantly putting them under, scrutiny, etc. And so, I've been to Guantanamo for other cases earlier, but from 2013 to 2020, I went to Guantanamo 10 times to cover, and I go as a journalist to cover the military commission of the 9/11 case, which is really one of the few things still happening now. And the one thing I would say is I go as a journalist because that's the only way to go. You can't go as a concerned citizen or as a sociologist of law, but I am a sociologist of law. And so being there, spending weeks at a time, and over years, enabled me to really come to understand sort of this triangulated conflict of interests that lies at the heart of that case. But the one thing I would say is the lesson we learn is that in this 9/11 case, and the fact that Guantanamo is still open, and the fact that, there are 35 people still there, including people who will never be charged or tried, is because you cannot erase torture, and there is no after torture. So we are still living in the age of torture, and Guantanamo is the most obvious and visible and enduring relic or emblem for that. Okay, so now I'm looking forward to the interlocutors. Thank you all for listening.
All right, so we've got you're good. We've got some furniture movement to do. So just bear with us for a second while we get everything set up.
I can sit over here. One more chair.
All right, but let's see.
Actually, do you want to bring- Oh,
Hello, friends. This is better.
Okay, are you good?
No, I'll take, and then turn the camera as well.
Yeah.
Andy, can you hear me?
Yes.
Yeah, we got you.
Great. Should I get going? Some thank yous and the rest. Hi, Naomi. Hi, Atif. It's great to see you all. Andy, do I have the floor?
Yes.
Well, first, let me say, Lisa, we are so grateful and delighted that you are here. I'm sorry I can't join you IRL, but I appreciate all the work that Andy and Nadine and Mark and other folks did in behind the scenes to make sure that we could make this an accessible event. And we have some folks here also in Zoomlandia. And so thank you for being here. Thank you for writing this beautiful book, which I'm holding in my hands. Thank you for writing it the way that you did in this accessible, true crime, riveting sort of tale that you're telling. You are offering this such a compelling and expansive portrait of this long war in court, the long, slow burn of people fighting this good fight against the machinery of US warfare state in ways that are so compelling. I think I want to start with an observation about the book that might feel sort of slantwise. That's sort of my approach generally. And then that will be my long wind up to the first question that I want to pose to you and that I hope that you'll take on. So as a Pisces, I'm always attentive to water. And there is a lot of water everywhere, all over this book. Not only, Lisa, because you're joining us from Santa Barbara and those glorious beaches of Santa Barbara, but because the genesis of your project, as you write, and a lot of the early writing happened while you were at sabbatical at seas, swimming in the ocean every day. I remember seeing you post those photographs fondly and thinking sort of jealously about how you modeled for me, and I think for all of us, what it means to bring pleasure and rejuvenation and rest into our work as we research and write about really heavy topics. So I want to thank you for that. And then I'm thinking about your time at AUB in Beirut on the Corniche and on the sea. And then in the fact that you start in the preface with this vignette about the targeted assassination of Osama bin Laden, of course, and Obama's reference to OBL's watery grave, right? And then, of course, this idea of water makes me think of Guantanamo itself, surrounded by water on all sides, this global military prison site on an island, seemingly peripheral to US prison logics, and yet, as you show us, the epicenter of some of the most important legal and ethical questions of the 21st century. And the idea of the sea is also making me think about this recent art exhibition of prisoner art from Guantanamo detainees that was called Ode to the Sea, Art from Guantanamo Bay, an exhibition I know that you're familiar with and the folks on the panel are, from 2017 to 2018 at the John Jay College of Criminal Justice in New York City. This was an exhibit that curated 36 paintings, drawings, and sculptures made by 8 men who were held at Guantanamo Bay Detention Center. And 4 of those men have been subsequently released. It's also making me think about a recent art exhibition that happened here in Chicago earlier this year at the DePaul Art Museum that was curated by my collaborator, Aaron Hughes, and a UC professor, Amber Ginsberg, that was called Remaking the Exceptional. It was a really brilliant show that highlighted the connections between policing and incarceration in Chicago and the human rights violations of the global war on terror. The exhibition featured, I think, probably the largest number of artworks from Guantanamo survivors and Guantanamo detainees, torture survivors, artists, activists, collectives that were thinking about creating visions of justice that connected local and global histories of war, torture, and confinement. And so I hope that helps frame some of our conversation with this hour. And, you know, it reminds me too that art and radical creative cultural production are offering us this antidote to all of the devastations that have been produced by the warfare state in our names over the last 2 decades. And, you know, something that I've argued about in my book and in my research is that our political imaginations are constantly being impoverished by these dominant perspectives of how we're supposed to think and feel about terrorism in the 21st century, and that we need artists and activists and healers and creative cultural practitioners of all stripes that'll give us new modes of perceiving and transforming the dystopian here and now, so that we're not living in this endless loop, this endless chaotic loop, as you've described. I'm thinking also about the work of the scholar Randall Williams, who argues in his book, The Divided World, about the fact that we need a sort of non-juridical reckoning with the past and present of imperialist violence. His argument is that our starting point should be neither the law nor any desire for a progressive appropriation of the law, but the mounting dead for whom the law either was a useless means of defense or an accomplice to their murder. And I think in addition to the dead and dying, we can also center the tortured, as you do in your work. So of course, that's bringing me now to my question to begin, which is that this book, you brilliantly argue that law is this supreme battleground. It's this double-edged sword, and as you see it, the only weapon to really adjudicate the crimes of the global war on terror, specifically torture. And so I guess I'm just curious, as you were writing this work and thinking about this long arc over the last decade plus, how has your confidence in this aspect of the argument in the war in court shifted, maybe even wavered in light of more recent events in the last few years, in light of all the ways that our legal system from the SCOTUS onwards, of course, has been so violently assailed and hijacked by all of these same players that you're detailing? All the ways that we know that law is this differentially applied tool based on modes of difference, that is often the site of violence rather than its resolution for minoritized and colonized peoples. And so I guess if I were to ask the question plainly to begin, it's what sustains your confidence that radical lawyering is the primary or sole vehicle for justice in this particular case of Guantanamo, but then also broadly, more broadly, given all of the struggles and permutations of the war on terror that face us in our moment today? How are you thinking about that centrality of law?
Okay, that's a great can they hear from here? That's
We
a
can hear you,
great.
and I can't see you, but Andy's
Okay,
moving.
yes.
There you are.
So it's a question that I've grappled with, and that lawyers, especially progressive lawyers who've been involved in these issues, grapple with as well. I have a very specific answer, which may, I mean, I kind of, I would agree, sure, let's have non-juridical reckonings and so on and so forth. But in this case, in the case of torture, there are two reasons why things could have gone in different directions, but it was because because the Bush administration legalized torture, and because people were held in custody, which is a legal relationship, and the custodial relationship meant, that at least lawyers, among others, would have to be involved. But the other reason, and this is where I, have some issue with some of the very progressive lawyers that I talked to, the reason it didn't have to only be lawyers, and the legal terrain didn't have to be the only battleground. It became the only battleground because the American public failed. The American public, there was no significant protests against torture. I mean, there was some protests against the Iraq War, but and part of the reason, that it was difficult for the public, the general American public to protest. A, there was a lot of secrecy. B, the issues were in fact incredibly complicated, like the question, the average person on the street, if you're going to say well, do the Geneva Conventions apply to people who are, and where does the jurisdictional, those kind of questions were very complicated. And so I mean, I think a lot of lawyers themselves, we're constantly wondering, what are we doing? And that's something you find when you have, human rights lawyers representing people in any kind of repressive regime. I'm sure Atif can say that as well, is that lawyers often wonder, am I actually legitimizing the very regime that is repressing my clients and repressing people? And so I think that is a super legitimate question, but in the absence of other alternatives, or along with other alternatives, if there were other alternatives, to the extent that there are legalized and legalistic relationships, I think it's crucial for lawyers to be involved. But absolutely, one can think, what I talk about in the book, particularly around the battles in court. So the book is written, I call it The War in Court, and it's written almost like a military history. It's written across time, because one battle, who's involved in the battle, who wins, who loses, what happens next, and that sets the ground for the next battle. There were a couple occasions when there were decisions, Rasul v. Bush, Hamdan v. Rumsfeld, and Boumediene v. Bush were the three sort of critical cases that only at the Supreme Court. But the US courts, other than that, absolutely failed. Congress absolutely failed. Because, and part of the reason, the old Monty Python saying, we didn't see the Inquisition coming, nobody saw a government authorized torture policy in the context of war, and so there was the kind of institutional, stasis was unable to deal with that. And I'd say that, the future should be there should be a non-juridical reckoning. There has to be a political reckoning. And I would just hope that to offer up this history that I do, it would maybe make people more confident, readers might be more confident to understand what the stakes are and take it out of the hands of lawyers. And so that it doesn't have to just be something that is or was a legal battle. So I hope that answers your question.
Beautiful, thank you.
Naomi, you know.
Were you done? Okay.
Yeah.
Okay. Wait, is Ronak frozen? Oh, no.
I'm still here. I have other questions, but I want everyone to have space.
So we'll have one question each, and we'll back, because.
All right, so thanks, Ronak, for those comments, and thank you, Lisa, for the book and for this talk. I also want to thank Nicole Nguyen and Andy Clarno and the Race and Empire Working Group. Oh, you're over here now. Okay. The Race and Empire Working Group and all the sponsors. So thanks so much for this opportunity to learn from Lisa's work. Okay, so we're here talking about the War in Court as we approach the 21st anniversary of the launching of the War on Terror and its accompanying global detention regime, which is not confined to Guantanamo. So nearly 21 years after it reopened as a detention center, this time for so-called enemy combatants, 35 people remain imprisoned at the Guantanamo camp. And among them, 20 have been cleared for release. 10 have been charged, but their cases remain stuck in the military commissions, made even more dysfunctional by their tortured, tainted evidence, which is the whole point of your book. 3 so-called forever prisoners are imprisoned without charge. And with the 2 convicted in military commissions, they are destined to die in a cage.
Actually, there's, well, okay.
Okay.
One of them, Majid Khan, actually served his sentence, but he's still stuck there. Yeah.
Okay.
Yeah.
Okay. But as Hajjar shows, it's crucial to remember that more than 700 survivors of Guantanamo have been released due to the activism of people of conscience outside, like Michael Ratner and the lawyers that your book highlights. And most important, more important than the lawyers, to the determined organizing and survival strategies of those imprisoned within its confines. So over the past 2 decades, it is really easy to forget how organizations like the Center for Constitutional Rights stood largely alone in their defense of Guantanamo's detainees following 9/11. A lot of these lawyers, as you point out, actually were international human rights lawyers located outside the US, right? So it's easy to forget that the US state didn't release any information about these detainees until compelled to do so by such legal and social justice organizing, largely out of the Russell V. Bush case. This is when we first learned their names or how many there were. Okay, so, and yet, as we stand here today, approaching the 21-year anniversary, we are unable to celebrate the closing of Guantanamo. And we know from the Haitian and Cuban migrants detained under death-inducing conditions there in the 1990s, that even if the camp were to close, the underlying conditions on which it has been built would remain stubbornly in place. The US would still imperially occupy this piece of Cuban territory, and the war on terror stretches into the future against a constantly shifting, quote, perpetual enemy who must always be fought but can never be vanquished, in the words of Ruth Wilson Gilmore. We cannot destroy this enemy without destroying ourselves along the way. And so I keep coming back to the 35 people who remain imprisoned. Even if the most scandalous abuses no longer pervade this camp, indefinite detention, the consistent heartbeat that undergirds Guantanamo's entire regime, is torture. This also means that the torture program is not over, and it will not end until the camp is closed. So from within the camp confines and once released from them, Guantanamo's prisoners have been testifying for decades that beyond the SCRE tactics, the stealth torture, the subjection to sensory overload and deprivation, exposure to freezing cold, the force feeding, the relegation to solitary confinement, it is the fact of their detention without knowing when or how they will be released that is torture. So approaching the question of torture from the perspective of detainees, rather than their lawyers or the legal structures and systems that they must abide, leads me to this kind of different conclusion that the torture program is not over. So reading their interpretations of their condition also enables a comparative analysis that connects Guantanamo to regular practices of US imprisonment and immigration regimes, which also subject their captives to radically depersonalizing strategies like prolonged isolation. And this came to bear in the 2013 hunger strikes, both in Pelican Bay and in Guantanamo Bay. And those organizers were actually trying to make those connections for the rest of us to see, right? So my question is somewhat similar to Ronak's. So how can movements and movement lawyering work towards exposing truth and obtaining justice for victims? This is what you argue in the conclusion, as well as accountability for perpetrators within existing legal systems, while moving beyond the limits of the state's legal regimes, which, as Ronak has helpfully pointed out, are a site of violence against people like so-called enemy combatants, people like Haitian migrants, et cetera, right? And so I kind of want to riff off the previous conversation that you had with Charlene Carruthers, right, about retributive or punitive justice versus restorative or transformative justice. And I'm also, again, kind of riffing off formerly detained people from Guantanamo, who on the one hand have, which is remarkable to me, because I know myself well enough to know that I'm not capable of this, but they have this incredible capacity for forgiveness. And so many of the formerly detained people have completely forgiven everyone who has tortured them, because they have realized in networking with other people who have been released from the camp that by not forgiving the people who subjected them to this radical depersonalization, that they were still in the camp, that they still had not left the camp. And so they had to do a lot of work to forgive the people who harmed them, right? Mohamedou Slahi, who's changed his name to Mohamedou Houbaini, actually has broken bread with some of the guards after his release. And he says that he has forgiven some of these people absolutely completely. And Mozambique had recently said that on the one hand, he has completely forgiven everyone who has harmed him. And also there is this hanging question of justice. And he is not capable as one person to forgive the entire system that led to his torture. Right. And so there needs to be some kind of other kind of process that leads to justice versus his ability to forgive the people who directly harmed him. And so I'm wondering, how do we put these two different kind of notions or these multiple notions of justice together? And how might knowledge coming from torture survivors themselves help expand those strategies that maybe lawyers could deploy in service of justice beyond the state?
Great, thank you. And actually, thank you so much, Naomi. And it also actually lets me come back just to commend Ronak on the question of art. I think that, Guantanamo has many legacies, most of them bad, and none of them over. But one of the powerful legacies is exactly what Naomi was highlighting, is the sort of those people who are out of Guantanamo, and some of whom have written powerful autobiographies. I mean, Mohamedou is one, Mansour Defi, and others. I mean, and of course, the organization that Mozambique is involved with, Cage, has been very central. It's based in London, about sort of putting all kinds of victims of the wars on terror, providing communal and the other kinds of things. And I think that it is in the writings and the artwork of people who have survived, and also just listening, reading their books, and one can find this unbelievable narrative of forgiveness in the statement that Majid Khan read at his sentencing hearing. He was one of the CIA torture victims, and he was the one, he was he'd been held in CIA custody for years, and then was one of the 14 that was brought. He willingly provided information. He became an informer of other people, because the role he had played, and to which he ultimately pled guilty, was passing money to people in Indonesia. And so in 2012, he pled guilty, so he was held off, and then finally he was sentenced. There was a sentencing hearing in 2021, and in this sentencing hearing, his statement has been made public. It's just a powerful sort of apology for his own role and the foolish things he made, but also just detailing what was done to him, and also elaborating on why he couldn't keep holding anger to those people. Hardly ever get emotional, but just thinking about it. So yeah, sorry.
See, there's more water. It's coming, more water.
Really, it's very rare, but so it is those narratives, I think, that are where the truth and forgiveness will lay, and that's what we'll think. I'm like the most unemotional person normally. Yeah. Anyway, so I think that the legacy of Guantanamo that's going to live best is going to be the art, the autobiographies, the accounts, the personal relationships. And so I think that that's something that's really powerful. So the lawyers could get to there. Thank you. Lawyers could, play a role in getting them out. But what the lives that some of these people have been, even like Omar Khader, who, was the first person, he was captured when he was 15 in Afghanistan. He was the first person that Obama prosecuted in the military commissions. He's a Canadian citizen. When he was out, it's like just the kind of, amazing person that he's become. And partially Omar Khader, found his humanity through this formerly totally right-wing military lawyer who, you know, changed his tune completely and like sort of helped, you know, Omar, just brings back all these memories of being, but sorry. Anyway, but so yes, thank you for your question.
I'm just gonna say, like, there are still people there,
Oh, yeah.
and the people, the 700 who have gotten out
Mhm.
are still living with it.
Right,
And that,
yes.
and so what you've been saying is that this is not over.
Oh, yeah.
And like, we should all be so upset about this.
Yeah.
So like, I appreciate like everything that you're saying, but also like the rage and like, the, you know, the
Yeah.
passion for the project that you're showing.
Thank you.
So thank you so much.
Thank you.
And I have to say too, that the heaviness that you're sharing with us is that you've been a keeper of these stories and your consistency of going to Guantanamo over and over again and making those trips and making that decision to tell this story, even when people have moved. This has become out of sight and out of mind in so many intense ways. And that's why we need that art and that healing more, you know, collectively, not only the folks who are most impacted by these systems, but the people who are the keepers of these stories and who are trying to proliferate the knowledge in that alternative mode of justice or plural form of justice that Naomi is speaking to. So thank you for your tears.
Thank you.
Thanks to Lisa for being here, and maybe you're starting from the tears and personal too. No, I have
It only
to.
happens once every 10 years.
Yeah, I know exactly. So maybe I will start with. There's lots of things to say, but with some personal anecdote and about torture and Lisa and me and also some uplifting maybe before I say questions and comments. One is that I wrote two books about torture as a human rights attorney. One is like in 2000 and one in 2008. And in 2008 was written as a graduate student. I was a graduate student in sociology in Michigan. And I was looking up reading, and I read Talal Asad and Anthropology of Torture. And then I saw Lisa Hajjar's work before we met, and I knew her. And I have to say, like, first, before I move on, like, I relate to this rage, and I had nightmares when I wrote my first two books about torture, and I knew many pro-democracy activists who were tortured in Egypt, and that was part of my anger. Like, I tried to transform nightmares into writing, and it was not easy, and it requires lots of patience and perseverance and bravery. So back to Lisa, when I was in 2006, 2008, I read Lisa's work in Merib. And I was so not only moved, and I have to say this not just to commend Lisa, but Lisa was one of my first academic heroes. And I admit that, wow, this is somebody who's working about the nuts and bolts of torture, writing sociology of torture in a very thoughtful way, not in a philosophy condemning rights and wrong. It's like how to take it into sociology, like the social science of torture. And it's also very humanistic too. And it was incredible. And it was just, I want to meet this person. And I was later knew one at Andy and other folks knew Lisa, and it was like, really. So before moving also to my question, the two quick comments to engage with what Ronak and Naomi said and move to my questions and comments. The first is to Ronak and this ongoing conversations about the limits of law, the laws. Not only dark side, the law in the imperial jurisdiction is all dark side. It's all continuing exception. It's ongoing exception. So really, what's the logic? What's the reason? What's the motivations? Where those lawyers are having the gut to continue this fight against the grain? It's not only the grain, military commission in a military base. What they are talking about? It's like the weirdest thing. So I agree, but for the same thing, not just about tears. And this is for the same reason when I read Lisa's work, earlier work, and this book is documenting this. Even if the legal mobilization doesn't matter, even if legal mobilization is not effective, documenting this and contributing to an epistemic shift, the production of knowledge. So Lisa's book, and I quote some of your last two paragraphs in the introduction about I'm writing this to teaching. I want to teach future generations about torture, and that was incredible. This is the epistemic shift about we want to document this. We are a nation of torture. US has a torture problem. We know that historically contributed, we manufactured, we are pioneers, US, and most democratic nations are pioneers, civilized, Western, whatever. We are pioneers in torture. And I had a double fold of like the extraordinary rendition program. That was my first dissertation topic. Egypt was part of it, Syria and other nations and so forth. So to comment on Ronak, I agree, but it's not only documenting is important. Documenting and historicizing what Lisa did is really important for us, for scholars, not only for activists, for scholars and for students of justice and of law and of sociology and of torture. To Naomi and this ongoing conversation about the legacy of Guantanamo or when the torture program really ends. Yes, I agree, it's ongoing. But the caveat or the minor caveat is not only when the camp is closed, really closed, but also when people, torturers and torture authorizers are put into accountability, really accountable. This is when the torture program really ends. And I agree with Lisa's analysis about Obama ending the program while not putting so it's not really ending the program and so forth. So I move to my questions. So the first question is about methodology. Here, my social scientist hat, and I want to learn, and I want our students and the Zoom audience to learn about how this is not only the patience, but the cleverness of like being a journalist and a social scientist, one of the leading scholars of sociology of torture and of law, going there to observe and go to Guantanamo. How you managed 14 times? What did you do there? How did you not only interviewing lawyers and others, but taking notes? How you managed doing methods in this exceptional circumstances and this weird site that under military jurisdiction, so that's one question. The second question about law and lawyering, if we agree that Lisa is one of the most badass, excuse my language, social scientists I've ever known, and like people who are writing about torture with this perseverance and like what you're doing sabbatical at seas and writing about torture, like writing about the most terrible things that humans can study, But those people, who are those lawyers? I want you to talk more about this sociology of those lawyers. You're talking in the book about they have this network that you call the Association for Get Mubar, with the Get Mubar, Bay Bar, and like their backgrounds. Who are they? How do you survive in this? What are I knew some of the names. I've met some of the ACLU and Center for Constitutional Rights. I know like virtually, but who are those superhumans? Like how do you, and as a social scientist, how you saw them? How as also as humans? Talk more about the sociology of the lawyers and lawyering in the context of what Ronak was saying. Is like there is no what are you talking about? Is like there is no law. It's an imperial sovereignty, imperial jurisdiction. It's a black hole. No difference between this and black holes in the extraordinary edition programs, other military bases in Europe and so forth. It's no law. It's the word the no managed jurisdiction. That's the imperial jurisdiction. Then the third question is about Guantanamo, and I know it's fascinating that we talk about Guantanamo but I cannot resist thinking about the many faces of Guantanamo in the book. Guantanamo as a military base, Guantanamo as a detention site, Guantanamo as an imperial history jurisdiction, imperial jurisdiction, Guantanamo as a like place for law, but it's also the closing but not closing. So and at the same time, it's still like while there is many faces of Guantanamo, it's still the same thing. It's a site where we can do whatever what we want. So it's on the one hand, it's the many faces of Guantanamo, and the big transformation that you're talking about in the book, from military base to like military commission side. Like how to reconcile these many faces of Guantanamo, and it's still the same thing. The, excuse my language, shitty imperial sovereignty, imperial jurisdiction side.
All right, so I'll boil down some of your questions to like really talking about how that it goes about. So let me just say that for any researcher doing any new thing, there's inevitably, you're going to feel insecure. Like when you start a project, you're going to feel like you're an imposter, like you want to understand something that you know when you start is way more complicated than you think. But even something as what may apparently, because one of the audience members, Stephen Thresher, who's like a highly experienced journalist, like the only way I could go to Guantanamo was to go as a journalist. But that meant I went with journalists, with real journalists, like people who are not like posing as a journalist. And so even just being with, Carol Rosenberg, it's like all hail to Carol Rosenberg, because we wouldn't know anything about Guantanamo, especially these days when she's almost the only one who still goes. I'll go whenever I can now. But it was like, I was insecure because they were real journalists, and like we'd go and like I would take notes like a scholar. I'd go into the court and I'd take my notes, or I'd sit in the media operations center and watch the commissions being, so that I could like live tweet, whether you go in or not. But the real journalists at the end of the day, they would all like rush back and they'd start typing their story, and I'd be sitting there going like, I think I'm going to write a piece on the role. Like 2 months later, my journalistic piece would come out, in that sense, because it wasn't really. So even that kind of like a little bit of an imposter syndrome, but there was something about going for so many times, and not as many times. Carol Rosenberg has been there like 2,000 times, but going there so often and being there for a longish enough period of time where you can really learn something. That's what ethnography really is about. It's really about like sort of immersing yourself in a context. But the same thing holds true of studying lawyers. Like, when I had come, earlier I had done I had the same kind of experience when I started on my PhD work on the Israeli military courts. I didn't know anything about Israeli military courts, so I was there to learn about it. But so it's like so coming into this project, like I always used to say, like, everything I know about American law before I started working on this book, I learned watching Law and Order. It was like I wasn't like, I didn't have like the deep understanding. And so, but so many lawyers, but they didn't know anything about torture. And so it was these kind of interesting dialogical relationships that would come, and I'm grateful for like the military lawyers I interviewed, the human rights lawyers, CCR and other folks, all the kinds of various lawyers. There were corporate lawyers, there were family law practitioners, etc., who helped me learn. That's like, I think the most powerful thing when you're doing ethnography is that you learn from your subjects, and your subjects help you learn what it is that they're trying to tell you. But one of the things that I just in terms of studying lawyers was that there's also, I think it's better to be a sociologist than a lawyer. It's better to be a sociologist studying this, because I would always tease them, like once we got these relationships, be like, lawyers are like you're down in the trenches, and sociologists are up on the mountaintop going, there's a battle over there, there's a battle over there, this is what your fighting means, And so it was something about that, positionality, but it was just an incredible experience of learning from so many different kinds of people, and just having this book was 20 years of research. So it's like in 20 years, you're like, you learned a lot. And then just like going to Guantanamo is weird. It's just like, it's a weird place. It never gets less weird. The journalists, like we stay in a place called Camp Justice, completely unironically called Camp Justice. The motto for Guantanamo was safe, humane, legal, and secure. And I think during the Trump administration, they dropped the safe and legal. They literally changed the motto of the place. But it's the weirdest place. And so the other thing is that, like, first of all, like the real journalists, but myself as well, because I've been in context with war. Guantanamo, for those who come in, we're all regarded as interlopers, right? The military, not the military lawyers, but the people who actually run the base and supervise the military commissions. They're just there doing their thing, and they regard the journalists, they sort of they drank the Kool-Aid, that like Guantanamo, they still call themselves war fighters, the people who work on the base. It's like, fucking kidding me? It's like, this is the most secure place on earth. Like, what is the war you're fighting against? Like, 5 foot tall, 92 pound, Abdurrahim al-Nashiri is your, like, you're in battle. But it's just, it's incredibly infantilizing, because like, we weren't, like, if we wanted to go for dinner, we'd have to like all decide, are we going to go to the Irish bar, or are we going to go to Subway? And then we'd all get in our little, it was like being like adults at summer camp. But then it's also like this very serious context. So there's just so many bizarre things. But the one thing I would say, like one of the great learning experiences, and it doesn't really happen because like hardly anybody goes now. There used to be in the earlier days during the Bush years and the Obama years, when there was still lots of people and there were some military commission cases going on, that, there'd be like 40, 50 people, like we say 25 journalists and another 15 NGO observers would be there. And we'd all stay in our separate tents and camp, we group tents, but tents in Camp Justice. But at night, we'd pull out our bottle of Bullet, bourbon that we bought at the Neck, and get our paper cups and sit under the stars and just like debate night after night what we were seeing, what we were learning, what it meant, what was happening. So it was just like a very intense learning experience with people who were all kind of doing their own thing. So that was also just a very intense part of the experience of learning. And it's just, I think, the last thing I would just say is I hope that, if I can convey some of the, curiosity and even the joy of doing this kind of work, it will inspire other people to like, don't shy away from these scary, weird topics. But there's a lot to, it's exciting to, work on these kinds of things. And actually, let me just maybe sort of loop it back to even what Ronak had said and Naomi had into. It's like, then what's the big lesson that we take? I think that we're all, we bring to our research our own personalities, what our personalities are. And, thank you, Andy, for reminding me of the, of course, I remember being here in whichever year it was and the thing, but I've always had, working on, issues of human rights, et cetera, but working on like war crimes and crimes of state. This question of restorative versus retributive justice and how we think about those things now. And it links very tightly to kind of the politics of prison abolition. That's actually it. But it's like, and I ended up getting into like a fight with Ruthie Gilmore, because I was like, we can't close the prisons until Dick Cheney has served at least a couple years in a maximum security lockdown. I'm willing to talk about prison abolition. And it was like, and that was really my position, was like, I feel like, and I think that there's a, huh?
You can't go on.
But he passed on.
Yeah.
You remember? Sorry,
Well, it's really, it was that kind of thing, but it almost raises a larger political question about American political culture. I feel like, we live in a country where cruelty, violence, racism, purposeful, intentional marginalizing of people who are, whatever. It's like, it's so baked into the national political culture. And you can even see it, with sort of what, the idea that like, oh my God, could Trump ever get indicted? It's like, why shouldn't he be marching in a 3-piece suit in an orange outfit, into, wherever, like, Florence, Supermax. But it's that idea that how do you ever, I always thought that one way, and this is just a speculative thought and everybody can completely disagree with me, but how do you get people to see what's wrong, why prison should be abolished, unless you put some of the people who are so powerful and whom so many people identify with into prison and make them suffer in that way. And then we can have the conversation about it. So that's always been my retributive justice position. So it's like, as soon as Dick Cheney is in a maximum security lockdown, then we can talk about, abolishing the prison.
Thank you.
Thanks, Lisa. We do have time for questions. And I'm going to see if I can set this computer up so that we can get questions from folks on Zoom. But you want to just handle questions from folks in the room
Oh, sure.
while I work on that?
Does anybody have any questions? Yes, Stephen Thrasher,
So,
Professor.
This
Stephen
is more
Thrasher.
of a comment than a question. Well, first, I want to take issue with you saying that you're not a journalist, you're not a real journalist. And Professor Hajjar was with some of my students the other day, and they were asking you about how you deal with some of these stories. And I think that the role of journalists can be many things, but so many journalists who actually do have access to these national security spaces are not really doing real journalism. They're acting as an intermediary for the state. They're not to maintain access. They're just sort of repeating what they're told to say. And so I think that you're doing an incredibly important form of journalism. And one of its central missions to give people information about things they wouldn't know. None of us will, most of us will never go to Guantanamo Bay. And you've really shared that with us in a really powerful way, with a really amazing perspective. And also the work that you were talking about, drinking bourbon because of journalists, like that's a really, like that I've been thinking about a lot with journalism students. You're so geared towards the byline and individual name, but like that work of thinking together and how to frame real complicated things is an incredibly important part of journalism. So thank you for that. And I also wanted to thank you for sharing your tears with us and looping back to what you were talking with the students the other night about how usually I do this too. Come from a place of anger and humor that drives you forward. But I really appreciate, again, I think my friend Lewis Wallace, who's one of the people I look up to most with journalism, is that we need more journalism and work that encounters and lets space work for our own vulnerability. So I thank you for sharing that with us, because that's a really important thing for people who do work as difficult as you.
Thank you. I mean, the one thing about the real journalism is, and I actually kind of do feel like a journalist, but it was like the people who had to file their stories. Like I was like, someday I'm going to produce a story. So, does anybody have any questions? Yes.
I was wondering when Naomi was talking about people that are still there, but also about people who've been released. And I had read something, and in fact, I saw something about a film that was done with in Saudi Arabia with the people who've been released there, sort of the education camps or something like that.
You're talking about the highly problematic jihad rehab that was made by a filmmaker named Meg Smacker. I totally recommend anybody to read Mustafa Bayoumie's review or sort of commentary on that particular film. The problem with that film, and in fact, she had actually, after she got slammed when the film showed in Toronto, I believe, and then like she wanted to figure out like, well, what's wrong with my movie, so she had reached out to various people, myself included, and I didn't know her, but so just for those of you who don't know, she spent like 3 years doing a documentary about people who had been released from Guantanamo and were undergoing, certain governments have like, and what they would even call like jihadi rehabilitation programs, Saudi Arabia being one of them. But so that's, and it's up. But the problem with the film was that like she just didn't, I mean, she was either naive or malicious in the sense that she was like, these are terrorists who are being reformed. So the presumptive veracity of their status as terrorists. And so her questioning, and what Mustafa Bayoumie brilliantly says is like, she wasn't a filmmaker, she was a cop. She was an interrogator. She was questioning them on the assumption that they were terrorists. And it's like, do you feel guilty about what you did? Even if the vast majority of people were swept up, sold for bounty, whatever it might have been, or were like fighting, had joined, gone in the 1990s to fight against the, communist regime in Afghanistan. And so the tenor of the film is so problematic, but also she never even got informed consent from them, because some of the people that she filmed, they didn't even know that this film was going to become public. So it's like, it's like a train wreck on so utterly many levels. But so I had actually watched the film, and my comment, because she said like, and I said, everything about your presumptions that these guys are guilty is wrong. Like you need to completely, if you're going to use anything, you've got to like re-edit it or something. I mean, I hadn't really thought so deeply about the consent issues, but it's a very problematic film. So don't bother watching it, but definitely read Mustafa Bayoumie's review in The Nation from this week, because it's very good.
There's a question online. Busaina, do you want to share your question?
So I think they can't unmute because they're on the train, so I'll read it out to everyone if you
Okay.
can hear me. Butaina Hatab is saying, thank you for this talk and to the interlocutors for your thoughtful questions. What advice would you give to aspiring lawyers looking to work against state crimes, incarceration, and other forms of systemic violence?
That's an excellent question. I mean, I always, until I was like in my 50s, like my dad passed away in 2020, but he was still like, I would be in my 50s and he'd be like, it's like, you're not too old to go to law school and get a real education, I was like, Dad, but I would just say that it's, getting a really good education before law school. I mean, like, because in some ways, law school, from what I understand, I never went to law school, but law school really trains people to think like lawyers. And that is not necessarily a great advantage. So you have to bring other things into the process. But there's so many really exciting initiatives around like enforcing international criminal law and efforts to hold state actors accountable and so on. So I think there are just, and this really only began, like international criminal law's enforceability only really starts taking off in the 1990s. So we're talking, not a huge amount of time, but there's a lot of avenues where people can be looking for, and even using their legal skills for restorative justice or, fighting against impunity and so on. I mean, there's many times I kind of regret that I didn't go to law school just because some of those, endeavors are so exciting, but I can just study them instead.
I'll also say Bethana, I worked with Bethana as the legal humanities intern. She has the goods. She is ready. She's ready to go. She's not going to get brainwashed by these law school things. And she's going to be ready. She's going to be the next gen.
Excellent. Nadine?
Just thank you so much. I just want to say that before my question, say as a younger scholar, many years ago, knowing your work, you could speak so many of us permission to not have fear of doing research in ways that was connected. That wasn't just a research project, like what you were doing, doing work that is the goal was to hold, torturers accountable. And long before it was okay to talk about Palestine and academia, you were trying to hold, Israel accountable in the international court.
Yeah.
I remember hearing about your work and seeing you speak back then. I was graduate student, whatever it was, just being like, wow, I didn't know anybody else in academia at the time who was doing what you're doing. And now look, you've done this work. So I just want to thank you so much for your work, your hard labor. And again, like that your work gave permission to many others, and especially in those things.
Can I say do you have a question? Because I want to say, I just want to say one thing about that. One thing I have found, and I've thought about this long and hard, like sort of first working on Israel, Israeli military courts and human rights violations and torture, et cetera. And now looking at the US, one thing that's made me kind of bulletproof, like I don't get the same shit that other people did. Like I think when you talk about the law, it scares people. Like your critics will like, wait, right. And more about like the violators of the law and why and how they're violated. And they, so it's like, it's actually, it's a positionality that has prevented me from facing a lot of the kind of backlashes that other people have. So you talk law talk. Okay. So your question.
I have two questions. They're related. That my brain thinks coalitionally and relationally, not necessarily by choice. So I was thinking about, all the work on anti-Arab and anti-Muslim racism and the connections to how we have many people have written on how just anti-Arab and anti-Muslim racism justifies these acts of torture. So I was just wondering if you wanted to speak at all about the connections between, say, Guantanamo and say the Muslim ban, or what Nicole and Andy have done a lot of work on around surveillance of Muslims in the US. That's one question, but there's another, relational question that I have, which is about police torture in the United States, and how it's almost like, this is a huge kind of word, it's like
you know, I don't know if it's the case that it's, and this isn't a question of Olympics thing, but it's just more of like, is this where the conversation is for you? Have you noticed that if we were to say like we want to abolish prisons, right, or defund the police versus like abolish the military, you know, and just to think of like, what are those conversations different or similar around holding cops accountable versus like holding the military accountable for acts?
Good questions. Excellent. So, you know, I mean, I think that Islamophobia is one. I mean, it's like when we're thinking about these issues of state-sanctioned violence and public acceptance or even applause of violence targeting certain kinds of people, there's, you know, strong locking connections among, you know, sort of the Muslim, et cetera. But so it reminded me of like, in terms of just thinking specifically for a moment about the torture program in the context of the war on terror, you know, it was the fact that like who perpetrated 9/11, you know, this, you know, particular, you know, Al-Qaeda had a particular point of view, and, you know, the individuals were, you know, Muslims, you know, having a very particular kind of ideology. But it was then like, you know, like the kind of argument that one makes about racial profiling, like they did it to us, why shouldn't we do it to them? It's like, in other words, you know, it's just like any other form of racism where people's individuality is just completely negated by their collective identity and the negative attributes of their collective identity. And indeed, you know, I think Naomi, you'd said something, but it reminded me, like, I'm working on another article now, but I was thinking about like what really motivated like the Cheneys and, you know, them to do this. And it was like, you know, I'm thinking it's this very neo-Hobbesian worldview. And if you have like a neo-Hobbesian worldview where it's like the eternal existential threats, you know, that you have to have the easily, you know, you have to be able to hook those perceptions of threat to justify your, you know, violent, you know, parading as security, but violent actions around like cognizable ideas. And so racism, Islamophobia, et cetera, just are the ways of, you know, it's a kind of a two-way street. Like you want to be neo-Hobbesian and you need to have somebody to feel existentially threatened by, and, you know, there's these groups. So I think it goes in those in cycles. In terms of police torture, I mean, the one thing, this is something that at the beginning, in the early years of the war on terror, when I started, you know, getting interested in these issues, because it was really, for me, coming out of my work on Israel and Palestine in the Israeli military court. So I was sort of acclimated to a war context. But like, I'm really good friends with Avery Gordon, and she was my colleague, and I mean, she retired just very recently at UCSB. But one of the things that she, you know, and I would have these conversations about, she was frustrated that all of a sudden, once, you know, people started thinking and talking about Guantanamo, like 2004, 2005, like that Guantanamo was everything. And what about, you know, all the terrible prisons and all the terrible things that happen, you know, in police stations and US prisons? I don't think it's an either or, but at all. I mean, in fact, there's absolutely, you know, the people, you know, it was a Chicago police torturer, right, you know, Richard Zulli, who tortured Mohammed Islahi, and, you know, Captain Collins. I definitely, one movie I do recommend everybody see is The Mauritanian. It's you know, but the so the idea, the difference though is really around, it falls around this question of law. And I mean, and this is, you know, so I'm not saying this is good or bad, but domestic issues like police violence within domestic national, you know, institutions, et cetera, it's harder to like kind of internationalize accountability. You can criticize it, et cetera, but if you really want to target it politically or legally, it's a totally different ballgame when you're dealing with international war, because the laws are different, you know, and I mean, like the Geneva Conventions, et cetera, there are international standards for international conflicts, whereas I mean, there exist standards that would apply, but many states disregard them. But you can't, at least you can operationalize the law when it's in the context of an international war, because of the different nature and different kind of enforceability of those laws and the violations of those laws. So that's been one sort of factor. But I hope that, you know, we should all appreciate the cross-fertilization of the horrific, protracted isolation and grotesque abuses and force feedings, etc., where a lot about Guantanamo looks a lot like Pelican Bay or Florence or whatever, and keep those things in mind. And I would just say that one of the lawyers that I got to know quite well, she's a Chicago lawyer. She was one of the 9/11, the lead attorneys, Cheryl Borman, and the reason she got involved in the 9/11 case was because Illinois ended the death penalty in 2011. She was a death penalty lawyer. She's like, what am I going to do now? Okay, I'm going to go represent Walid bin Attash, in the 9/11 case. And but she's now back and she's running. I think she's in charge, or she's at least very active, if not the head of the commission to provide justice for the victims of Chicago police torture and that kind of thing. So there is this kind of really human cross-fertilization going on.
Oh, go.
What's the different names if you want to get up?
Well, it feels like your response to Nadine's question also for me is raising the question of we can't close the prisons until Cheney serves time,
Well, I mean,
right?
but I'm only
So,
one person
yeah.
who really hates Cheney.
I really hate Cheney too. And when Donald Rumsfeld died in peace, surrounded by family, I had a lot of feelings about that.
Right.
And none of them were positive.
Right.
Right.
I wrote Henry Kissinger's obituary in 2016. I'm waiting.
Oh my God. When is he going to die? Oh my God.
Sitting on the back end of Genitalia.
Yeah.
So when he dies, it'll
be ready. You're ready. I'm ready. But at the same time, locking up Dick Cheney, George W. Bush, Donald Rumsfeld, all of them, like John Yoo, I don't see how that's going to change the political culture and move us closer to accountability. I don't think it will end torture. I don't think it'll end extrajudicial jurisdictions or U.S. empire. So I'm Korean. I believe in revenge as a genetic thing, but this is where I struggle. I really struggle with this so much. But I want to hear Nicole's question too.
Yeah, I don't have a better answer. I think my that particular strain of thought is just very impulsive and emotional.
Comments about this too.
So not to return to jihad rehab, but there is when we talk about Guantanamo, there's often a focus on the innocent people who are in Guantanamo.
Yes.
In a way that means that is an easier conversation about closing Guantanamo, that there are innocent people scooped up, and leaves untouched a question, the fact that there are people who commit acts of political violence, and we don't have a response to that, which then perpetuates the peripheral logic that drives Guantanamo, the war on terror. And so how do we take the case of the legal fight over Guantanamo to think more holistically about political violence more generally, and also sort of what's driving the war on terror?
Right. Well, I think that's absolutely pertinent to the 9/11 case. I mean, the 3 death penalty case. Well, I don't know if there's 2 death penalty cases, although it was the 9/11 case. I mean, 2,976 people were killed on 9/11 itself, not to, etc. And so certainly at least 2 of the 5 were knowledgeable and, made possible, the 9/11 attacks. The other 2 of them were money men who didn't really know what they were transferring money until after the money had been transferred. So they're sort of, or at least that's the allegations. And then one guy who didn't know exactly what he was doing, but he trained the hijackers how to fight in close contact. But so the point being that if you were going to say these are horrific crimes and they should be held legally accountable, but the government forfeited its right to execute them by torturing them. And it's actually now so in other words, it doesn't negate culpability and certainly it does not negate the demands for justice by all the victim family members, or the other cases, the bombing of the USS Cole, which killed 17 sailors. But it is, if we really go back and think about it, if the police really fuck up something in a murder trial, that person may walk free because the government isn't allowed to you're not allowed to prosecute somebody if the things have been so fucked up.
But if we did that beautifully, right, and we got KSM, right, or not, right, anybody who commits an act of violence, we detain them, whatever, legally and in a nice kind of way.
I think we don't have an answer for what like we've decided to lock up those people, right? And I guess I'm asking, what alternative is there? Because focusing on the innocent means we don't have to get into the gnarly details of why people are committing acts of violence, right? So it then means like we have to end US empire, right? Rather than locking up the people. So I think that's my question of like, if everything had gone to like the way, I mean, it was legal at Guantanamo, but the way that we think that police procedure should unfold, like just suspending for evaluation for a second, right? Then what is it that we do with people who commit acts of violence?
Well, I mean, in that, I mean, so I actually don't necessarily have a specific answer to that, but I would say this, like one reason why, you know, the 9/11 case was so important, and it is, and it will be so important, regardless, I mean, they're now in plea bargain negotiations, was because these lawyers, the lawyers who signed on, who volunteered to be the defense lawyers, you know, the learned counsels, and so every one of them had like, you know, one or two death penalty lawyers, plus a military lawyer, plus, and then you know, because it's gone on for so long, it's changed. But let's just use the example of the lawyers, the team of lawyers for Khalid Sheikh Mohammed. So he has, you know, confessed to being the mastermind of 9/11. But, you know, what happens in a death penalty case, and this is something I really learned because I've not really dealt with death penalty cases or studying it before, was his lawyers. Let's just use the example of David Nevin, who was his learned counsel for a long time. David Nevin didn't know shit about the Middle East or anything before. I mean, like he learned it, but it's like David Nevin over the years was acquiring information because he basically wanted, he said, you know, my client, I'm not going to excuse what my client did. There's no justification for killing innocent people, but he did it for reasons. He did it because, you know, he grew up in Kuwait and he was, you know, like, and he got to know lots of Palestinians growing up and he was resentful of the US relationship. He's like, you know, that was a factor. He, you know, was angered by the sanctions in Iraq that killed thousands, hundreds of thousands of people, you know, the US imposed sanctions. So his idea was if this case went to trial, he was going to use this trial to put, you know, US empire on trial. And then some of the other ones were as well. I mean, that's sort of the way in which you would argue that. And now, because, you know, there just can't be any, I mean, I think the government has finally thrown up its hands and they're now in plea bargain negotiations. They're not going to be able to kill Khalid Sheikh Mohammed. And they're in fact negotiating. I mean, his lawyers are now demanding that, you know, he'll accept a life sentence, you know, a life sentence, but he doesn't want to be in isolation. And so that's actually the negotiation that they're having now, is that, and they don't want to be moved onto the mainland. They actually want to stay at Guantanamo, but under better conditions. Like they want to stay together as long as, I mean, Khalid Sheikh Mohammed is probably the only one that will get a natural life sentence in the plea bargain. But the other, so that's one of those things where, you know, sometimes trials really are like theaters of politics. I mean, you can do more. You can make political and historical cases through trials. And I think that was something that would be, you know, would have been with the 9/11 case. And even if, you know, if it does go to a plea bargain, you know, I think that future whomever, sociologists or whomever, like there's like tens and tens of thousands of pages of military commission transcripts. I mean, you can like do some really juicy PhD dissertations on that stuff, even if, you know, those guys are, you know, the case is over. That's American history right there, you know, is all the military commission transcripts. So I don't think I answered your question.
So we have a question here, but I have also was one comment too.
We also,
If the time or
yeah, I don't know. I can't see what time it is.
Yeah.
you,
It's 6, yeah.
you are
How
the
you
leader.
feeling?
5
I'm
minutes?
fine, but I mean, do you
Yeah.
want to do like 5 more minutes?
Yeah, can we just take the 2 questions and then
Yes.
be?
And I'll make it
and then
short.
finish?
Okay.
Well, I guess I want to go back to sort of the deep state kind of element of like Rumsfeld, Cheney, Bush and Kissinger, and that whole sort of anti-political order, political in the strictest sense, of like that very clandestine Pentagon style, top down, you know, the hand that I played in the outcome of 9/11, you know, immediately after you have the Patriot Act, which is this like, you know, far reaching and like really ultimately detrimental political subversion. and the continuity of government stuff. You know, I wonder how undermining Guantanamo and abolishing Guantanamo and the sort of the legal precedent of Guantanamo, what do you think that poses, if at all, a threat to that Patriot Act, kind of the grander implication of this, like, we can kind of just do something as the government can kind of just do something, or the state can just do something, and then kind of like cover their ass in the aftermath by saying, well, we can say this, we can do that, we can kind of spin these quasi-legal stories about it. And I wonder if, you know, the hopefully soon or the eventual end of Guantanamo poses kind of a death blow to that continuity of governments.
Well, I'll tell you one thing that we should, the one way in which, you know, Guantanamo, not the literal specific base on the island, but like Guantanamo, the larger metaphorical thing, it will not go away. I mean, it will, I mean, regardless of what happens, it's like the expansion of executive power, the, you know, the secrets that were, you know, are being kept because of the fact that they, you know, obscure certain utterly humiliating things, but the argument is always like, oh, it's like national security will be at risk. Those things that were maybe instituted during the Bush administration had not gone away. I mean, the Obama's expansion of drone warfare relied entirely on new paradigm logic. Absolutely. Trump's expansion of executive power further, like doing away with the very, you know, Obama in his second term tried to kind of rein in drone warfare by imposing certain kinds of legal limits, and Trump like did away with that. And, you know, Biden is still, you know, we're still engaged in, you know, covert wars in at least 16 countries or 17 countries up until now. And so those things, you know, it's kind of like when a government, when an institutional figure like a government, you know, gets expanded power, they're not going to give it up voluntarily. And you think about what was at times when there was even slight rollbacks of, or like reforms of expansive power. It was the exposure of COINTELPRO, the Watergate scandal, and the loss of the Vietnam War that like sort of motivated the country to institute certain legal and political reforms. And those were the very reforms that Cheney et al. Sought to override. So it's like there can be a crisis sometime, but barring some kind of crisis that causes the institutional actors to look within themselves, we're still living in the new paradigm age, and it will continue as long as, you know, it may move to different kinds of settings or different kinds of, you know, abuses, but it is there until it gets expunged like you know, an enema.
Yeah.
Even more water to end the conversation.
Yeah, I know, I don't want to end in not a good note, but I'll leave the final word to Lisa. But I have just all this deeper question about when torture really will end, or when justice really happen. That's a deeper question that I'm really thinking through from all these threads. And I don't have an answer. I'm just raising some questions based on the conversation and Lisa's wonderful book, because and also Nicole, like we should dismantle the empire. But I want to, this is part of my starting the 1 minute comment, and then I'll leave it to you, is that we are we are leaders of torture, but we are a country of law, supposedly, right? It's like a paradoxic, it's an inherent tension that you can't resolve. We are a republic and an empire. This is like what I think of it as, like the imperial existential paradox or identity crisis. Like we can't play both ways. You can't be a republic and an empire. And that's why the law is in the trench, but it's silence at the same time. So have all these examples from your book, nothing major, but it's like how Obama ending the program without putting torturers into accountable. That's American thing. That's so no difference between Obama and like, you know, and also how the torture continues in electoral politics. It's also in the book about, and there is no bluntly anti-torture candidates, except for some exceptions. That's this is like an ongoing thing. Like we can't stop this. And not only this, national security is defined mostly by executives. That's American doctrine.
Right.
Like, changing the paradigms of American doctrines, and so forth. National security privilege in courts, no matter what, military tribunal, orderly courts. This is American. And also with the, and Nadine's question about the public, and you too, like in the book, and about the public tolerates and accepting torture. And it's not just because of Islamophobia or the anti-Arab or Muslim, maybe because of the war on terror. This is a deeper thing about that. Is it when the public would really stand against torture? That's like the deeper American, something we need to discuss.
Well, I would just say that
but-
that's actually was the purpose of writing this book, writing it as a trade book, but it's like writing it to help people understand, like not only what happened, but to give people the tools of understanding some of the legal issues. So it's kind of like I'm an arms maker in a metaphorical sort of sense, and I'm like, like take my weapons and like go forth and let it be to thinking about how people will expect certain things. If they understand things more deeply, they may expect things. So that's what all scholars
And
do when we
it's-
write
which
for,
is
we
amazing.
all do it.
Incredible contributions to all of us.
Well, thank you guys
Thanks.
for having me.
Yeah,
Thanks, Ronan.
Thank you so
Yeah,
much.
thank you, Rona. Thanks, Atif, and Naomi. Thank you,
Thanks
sir.
so much.